Hello friends, my name is Amit Jyoti. I'm working as an assistant professor with the O.P. Jindal Global University. This module is titled as The Teachings of the Publicist. Article 38(1)(d) of the ICJ statute enumerates two subsidiary sources of international law for determination of the rule of law: judicial decisions and the teachings of the most highly qualified publicists of the various nations. The most anticipated reasons for considering the teachings of publicists as subsidiary source of international law is that they may often be influenced by political circumstances and have a national bias. These teachings can generally be understood as scholarly writings of acknowledged authorities on specific areas of international law. These teachings may be of individual authors or can be works produced by a group of scholars working collectively in organizations like the International Law Commission, Amnesty International, Human Rights Council, etc. Sources of these teachings include treatises and legal periodicals. Textbooks, journal articles, and essays are used as a method of discovering what the law is on any particular point rather than as the source of actual rules, and the writings of even the most respected international publicists cannot create law. Writers and publicists have indeed played an important role in the formative period and growth of international law. The teachings of publicists are regularly cited in the judgments of international criminal courts and tribunals. Teachings of publicists have often been used to demonstrate widespread state practice, interpret a treaty provision, demonstrate a general principle of law, explain the practice of the court itself, provide general context for a specific point or case, demonstrate the existence of a rule of law, and advocate for a change in the law. The use of the undefined words most highly qualified publicist under Article 38(1)(d) is ambiguous, as it seems problematic to ascertain who are the most highly qualified publicists in the concerned field of international law. There may often be dispute over who is highly qualified publicist as such, because it's a relative standard rather than being an objective criteria. Lee Peoples, in his research guide on teachings of most qualified publicists, has attempted to provide a criteria to evaluate textbooks, articles, essays, periodicals, and reports published by individuals and institutions. These criteria are: author's reputation, that is, has the work been reviewed? If so, was the review favorable? What else has the person written? Have their articles been published in selective journals? Are their books held by many libraries? Are they well respected or considered an expert in the field by others, not just themselves? Do they practice, and if so, in what areas and with what firm? Have they practiced before foreign or international tribunals or handled any well-known cases? What degrees do they hold? If they are an academic, where do they teach and what? Other factor being publisher's reputation, the organization of the material in the publication, style and readability of the material, that is the material scholarly, that is whether it includes discussions of how the law has evolved over time, jurisprudential theories, public policy concerns, with lots of citations to other treatises and law and review articles, or is it more practice oriented? Another factor being scholarly attributes and reference features, availability online, comparison with other titles on the subject, date of the publications to see that have the changes occurred recently in the area of law that make the work more important. Is the work considered a classic despite its age? How is the work updated? Is there another title on the subject published more recently? So after these factors, let us look at the historical background of the source listed under Article 38. Article 38 has been taken verbatim from the Statute of the Permanent Court of International Justice. In 1920, when the Advisory Committee, the multinational committee of experts, was tasked by the League of Nations to draft the PCIJ statute of the jurists, they were drafting a precursor to Article 38(1)(d). President Descamps proposed of the following text, which stated, "International jurisprudence as a means for the application and development of law." There was no mention of teachings as source in that draft. A subsequent vision of the text introduced a reference to the opinions of writers. After some discussions, President Descamps suggested that some objective justice must be introduced to the list of the following sources, that is, to the list consisting of conventions, custom, the legal conscience of civilized nations, and international jurisprudence. He identified teachings as rules of objective justice, envisaging a situation where the judge may know what is objectively right, but he may not take the course in absence of a convention or a custom. In such situations, the judge should be allowed to use the concurrent teaching of the authors whose opinions have an authority. Descamps explained, if neither treaty law nor custom existed, could the judge pronounce a non-liquid? In such situation, if the judge decides to apply general principles of law, he may be inclined to apply them according to his own understanding. Therefore, he suggested the inclusion of the doctrine of the publicist carrying authority as sources of law. Thereafter, the revised draft stated the source as the opinions of writers as a means for the application and development of law. Then, after several arguments between committee members on whether it is feasible to include such a doctrine, if so, on what standards, and whether sovereign states will accept judgments based on opinions of legal writers. The compromise provision read, "The doctrines of the best qualified writers of the various nations as a means for the application and development of law." It was later revised as rules of law derived from the teachings of the most highly qualified publicists of the various nations, to which Descamps suggested adding as subsidiary means for the determination of rules of law, which was adopted as the final text. Therefore, the result of various disagreements between the committee members was this ambiguous provision that we have today. Another probable cause of listing teachings of most highly qualified publicists can be inferred from Oppenheim's statement in his article, "The Science of International Law, Its Task and Method," where he stated, "Apart from the International Prize Court agreed upon by the Second Hague Peace Conference, but not yet established, there are no international courts in existence which can define these customary rules and apply them authoritatively to cases which themselves become precedents, binding upon inferior courts. The writers on international law, and in special the authors of treaties, have in a sense to take the place of judges and have to pronounce whether there is an established custom or not, whether there is a usage in the contradistinction to a custom, whether a recognized usage has now ripened into a custom, and the like. It is for this reason that textbooks of international law have so much more importance for the application of law than the textbooks of other branches of the law. In fact, Fitzmaurice stated that, and I quote, "A decision is a fact, an opinion, however cogent, remains an opinion. And comparatively, judicial decisions have a more direct and immediate impact on the realities of international life." Unquote. Now let's look at the development of human rights law through teachings of most highly qualified publicists. The ICJ has cited Publicists in only 22 of its 139 judgments and advisory opinions. It may be observed that courts have rather been reserved in resorting to this source in giving judgments. The writings of scholars contribute to the development and analysis of human rights law. Compared to the formal standard setting of international organs, the impact is indirect. The teachings of most of the highly qualified publicists can be found in books, articles, bulletins, annual reports, commentaries, blogs, etc., by legal scholars working individually or as a part of an institution. It is important to consider the publicist's standing in the international legal community and the degree to which the publicist's views are shared by others. For scholars who are widely known and respected are more persuasive than scholars who are less familiar to the court. Influential contributions have been made by scholars and experts working in human rights fora. For instance, in the UN Subcommission on the Promotion and Protection of Human Rights, United Nations Human Rights Council, as well as by highly regarded NGOs such as Amnesty International, Human Rights Watch, and the International Commission of Jurists. Pursuant to Article 13, Para 1 of the UN Charter, the ILC was established by resolution of the UN General Assembly in 1947 to initiate studies and make recommendations for the purpose of encouraging the progressive development of international law and its codification. In performing its dual responsibility of progressive development and codification, the ILC drafts conventions on the subjects that are not sufficiently developed and formalize and systematize the rules that have emerged from state practice or precedent and teachings. It is comprised of 34 members who are elected by the General Assembly, who are drawn from academic, diplomacy, government ministries, and international organizations. To promote the codification of international law, the ILC publishes draft articles setting out what it considers to be rules of customary international law, where there has already been extensive state practice, precedent, and doctrine. These draft articles are accompanied by commentaries written by a special rapporteur who is appointed by the ILC and it provides illustrative cases and analysis critical to a thorough understanding of the law sought to be codified. Each year, the ILC publishes its yearbook of the International Law Commission, which consists of its annual report to the General Assembly as well as any draft articles and commentaries adopted at its annual plenary session. It was concluded by Michael Pale in a survey that the International Law Commission is far and away the most common source relied upon by the judges. The courts have often made use of the drafts and final publications of ILC and also the discussion in the ILC yearbook and to the conclusions reported by its rapporteurs. In the realm of international human rights law, the ILC has published 1. Report on reservations to multilateral conventions, another Code of Crimes against the Peace and Security of Mankind, another publication is Crimes Against Humanity, and text on Jus Cogens. Let's now discuss the role of United Nations Human Rights Council. The United Nations Human Rights Council is United Nations intergovernmental body which comprises of 47 states that are responsible for the promotion and protection of all human rights around the globe. It is established as a universal periodic review mechanism to assess the human rights situation in all the United Nations member states and has an advisory committee which serves as the Council's think tank, providing it with expertise and advice on thematic human rights issues and the complaint procedure which allows individuals and organizations to bring human rights violations to the attention of the Council. UNHRC produces an extensive range of publications on a variety of topics related to human rights, which may be a resourceful guide for the court in delivering justice. Let's next discuss the role of Amnesty International. Amnesty International is a non-governmental organization, an NGO, that was started in 1961 in London, focusing on human rights with over 7 million members and supporters around the world. Its objective is to conduct research and generate action to prevent and end grave abuses of human rights and to demand justice for those whose rights have been violated by initiating campaigns in various forms. It annually publishes a report highlighting the state of human rights in countries around the world with an aim to mobilize the policymakers, jurists and academia to stand up for human rights. Next, let's talk about Human Rights Watch. Human Rights Watch is another non-governmental human rights organization which was established in the year 1978. It now comprises of about 400 members including country experts, lawyers, journalists and academics of diverse backgrounds and nationalities. Its primary role is fact-finding, impartial reporting, effective use of media and targeted advocacy. It annually publishes around 100 reports, briefs on human rights issues around the world. These reports focus on specific issues within countries and regions like arms, business and human rights, children's rights, terrorism and counterterrorism, health and human rights, international justice, lesbian, gay, bisexual and transgender rights, refugees and women's rights. Let us now discuss about International Commission of Jurists. International Commission of Jurists is another dynamic non-governmental human rights organization which is based in Geneva. It was established in 1952 and consists of 60 eminent judges and lawyers from all regions of the world who strive to promote and protect human rights through the rule of law by using its unique legal expertise to develop and strengthen national and international justice systems. International Commission of Jurists endeavors to ensure that international law, especially human rights and humanitarian law, is utilized effectively for protection and particularly for the most vulnerable, and is implemented through effective national and international procedures. It aims to assist judges and lawyers and prosecutors acting under the highest ethical standards and professional integrity to be independent, impartial, and free to carry out their professional duties. It publishes an annual report, a monthly bulletin, and other reports on current issues reporting the incidence of human rights violations and proposing adequate changes. The Institut de Droit International, the International Law Association, the ICRC, and the American Law Institute are some other institutions that have also been referred to by the courts and individual judges in their decisions. The works published by the organizations above are often scholarly, well-researched, and analytical. They are published for spreading awareness on the issue of human rights violations, and they provide analysis, gain media attention, and are able to make their voices reach to those who are responsible for dispensing justice. Therefore, to conclude, we can say that teachings of publicists are an important and influential subsidiary means for the determination of rules of international law. But these teachings are certainly not rules to be applied, but to be resorted to for finding applicable rules. As we observed in our discussion, the courts may rarely invoke scholarly opinions in their judgments, but this has not stopped lawyers from drawing courts' attention to teachings of the publicist. On this, Sir Waldock, later a judge of ICJ, observes, and he states, I quote, "The way in which individual judges quite often make use of them in their separate opinion indicates that they have played a part in the internal deliberations of the court and in shaping opinion. These scholarly works serve as persuasive guide to the content and may be relied upon for information and analysis of a specific human rights violation. But there is a danger of misunderstanding when an isolated passage from a book or an article is referred to, and it may not adequately reflect on the thoughts of the author. Also, in the author's opinion, another disadvantage of the source is that when Article 38(1)(d) was drafted, there were 2 less nations and qualified publicists as compared to the current situation. In those times, relying on scholarly opinion was a feasible option, but with the existing number of scholars and their intellectual contributions, this source shall not assist the court in interpretation of law, but it can rather create contradistinctions as there will be numerous opinions on one point. Many of the intellectual writings may also have political overtones. Therefore, these considerations must be kept in mind. Thank you.